Wiping the slate clean if you're in debt sounds like an attractive proposition, but in this video I'm going to explore some of the downsides of bankruptcy. You'll learn about the cost of bankruptcy, the debts that remain, and how it might affect your employment, your housing, and your future finances. I'm Daniel Barnett, a barrister practicing in central London, and I'm the presenter of the Legal Hour on LBC Radio. This is one of a series of videos I've made about bankruptcy. Now, it goes without saying that you have to give up control of your financial affairs if you go bankrupt, but you also have to give up your non-essential possessions. These are confiscated, and if your essential possessions are valuable, they can also be taken by your trustee and replaced with cheaper alternatives. You'll be allocated money for daily living costs, but it's likely you'll have to make fundamental lifestyle adjustments. Going bankrupt is actually a really expensive process. Before your creditors are paid, if you've got assets, money is taken to pay for the bankruptcy process. If you applied for your own bankruptcy, the fee is just under £2,000, and if someone else applied, the fee is £2,775. There's also a general fee of £6,000, and 15% of the total value of the assets given away is also taken as fees, known as an asset realisation fee. There's also a fee charged at an hourly rate for distributing money to creditors. That means a huge amount of your assets will go in paying fees before the creditors see a penny. If an insolvency practitioner handles your bankruptcy, you have to pay the administration and general fees, but the practitioner will have their own charges, which you'll pay instead of the asset realisation and distribution fees. You should ask how much they will charge before they take on your case. Having incurred these costs, not all debts will then be waived. Just before I move on to discuss the debts, can I ask you please, if you wouldn't mind, subscribe to this channel and click the notification bell so you remain up to date with all my latest explainer videos. I'll give you 4 seconds. 4, 3, 2, 1. Thank you. Secure debts are not covered by bankruptcy. These include magistrates' court fines, court payments under a confiscation order, maintenance and child support payments, student debts, debts owed because of personal injury or the debt of another person, and social fund loans. You also have to keep paying your mortgage and other debts on your home. If you have a debt that's shared with somebody else and you include that debt in your bankruptcy, the creditor can then ask the other person for the whole amount that's owed. You can't apply jointly for bankruptcy, you and the other person would have to apply individually. Similarly, if someone else is a guarantor for a loan you've taken out, your bankruptcy will include the loan, but since the other person has guaranteed it, they'll probably have to end up paying the debt under their guarantee. Flipping that, if you've guaranteed someone else's debt and the other person can't pay it off, your liability under the guarantee is included in your bankruptcy and the creditor can't ask you to pay it off. Think about how all these rules will apply specifically to you, and then think carefully, because once you've submitted your bankruptcy application, you can't change your mind. Let's have a look at how bankruptcy affects your employment, your housing, and your future finances. Generally, it's unlikely your bankruptcy will affect your job, but you should check your employment contract in case you have to declare your situation to your employer. If you're a senior executive or a director, it's possible your service agreement says your employment terminates automatically if you're declared insolvent. In specific fields, going bankrupt has specific implications. If your job involves handling financial matters, for example, if you work at a bank, then your employer may no longer want to employ you, or they may place restrictions on the kind of work you're allowed to do. And bankruptcy could also disqualify you from certain professional bodies, meaning you would lose your license to practice. Step Change, a leading UK debt charity, lists the fields which might be affected, including law, accountancy, financial services, and certain roles within the gambling industry. It's worth checking with your professional regulator. It almost goes without saying that you would no longer be able to work as an insolvency practitioner. And you might still feel the impact if you decide to switch careers later on. For instance, it might be harder to get a job working for the police, the civil service, or in the security industry. If you want to run a business, there are further restrictions, and if you break them, you'll be committing a criminal offence. For example, if you're bankrupt, you have to get permission from the court to be a company director. You also need permission from the court to set up, promote, or manage a limited company. Even if your work is unaffected, your home may be at risk. It will probably have to be sold if your receiver decides it will help to pay off your debts. Your beneficial interest is the amount of money that you might receive once you've paid off any secured loans on your house, like a mortgage. The trustee takes both your beneficial interest and the legal title, that's the document proving you own the house. They now control your house, and they can sell it if necessary. A bankruptcy restriction is added to the land registry, and that means you can't sell the property or mortgage it again. The restriction is taken off once your bankruptcy has been concluded. If you're the joint owner of the house, your beneficial interest is just your share of the property after secured loans have been paid, and that share transfers to the trustee. But there's no bankruptcy restriction in that situation, meaning you can still make some deals connected to the house or sell it. The trustee is told of any such deal, and if the house is sold, the trustee is given your share of the money from the sale. If you have a family or if you have dependents, you might be able to put off the sale of your home for a year or so that you can find somewhere else to live. But signing over your house to somebody else to avoid it being sold amounts to a bankruptcy offence. If your share of the house is less than £1,000, your house won't be sold. But after 2 years and 3 months, your share of the property is checked again. If it's still less than £1,000, your home probably won't be sold and your beneficial interest will revert to you. The receiver has 3 years to make a decision about your home. If you rent your home, there are circumstances in which you might be evicted due to bankruptcy. For instance, if your tenancy agreement says you can't become a tenant once you're bankrupt. If you're in arrears and your landlord has already got plans to evict you, you'll most likely have to leave the property. You have to tell anyone who offers you a loan of over £500 that you're bankrupt, or that you've been bankrupt before. If you don't tell them, you're committing a criminal offence. You can get a basic bank account after your bankruptcy order's been made, but you have to tell the bank or building society about your situation. Your bankruptcy also shows up on your credit reference file, which is what a credit provider will check when making financial decisions about you. This note will show that you've struggled to repay in the past and will reduce your chance of being given credit. It stays on your file for 6 years. Finally, it's worth noting also that bankruptcy is a public process and your name is placed on the individual insolvency register. That has further consequences for future credit. So what may seem like a simple solution actually comes with a long tail of implications. If it was an option you were considering but you're now having second thoughts, please do look at my video on alternatives to bankruptcy. I'm Daniel Barnett. Please do subscribe to this channel. Thank you for watching. Bye bye.